Hi everyone, my name is Engineer Vandana Sharma and I welcome you in this tutorial of Patent Cooperation Treaty. So before we start, I would like to give essential credits to WIPO Academy, which has actually equipped me with this skill. I have recently completed my certification course on PCT, and after learning from that module, I am here in front of you to share my experience, to share my learnings with you. So we'll learn about PCT, what exact route an application follows and how the procedure goes up. So this is going to be a series of 7 to 8 sessions. We'll start with this first session. Now let's understand what is PCT. The Patent Cooperation Treaty is an international agreement that allows inventors to file a single patent application to seek patent protection in multiple countries. This is an efficient and economical way to support applicants, inventors, and national patent officers. While the PCT simplifies the initial filing process, it does not guarantee the issuance of a patent. The ultimate decision to grant a patent rests solely with the respective national or regional patent offices. The PCT was signed in Washington, D.C. in June 1970 and became operational in June 1978 with 18 contracting states. Today, the PCT has 157 contracting states, including India, which joined the treaty on December 7, 1998. So in this particular slide, uh, we actually just wanted to understand what is PCT, and in return we got to know that PCT is actually an easier process for inventors and for the applicants, wherein they can file a single application, they can actually get a priority date, and then later on they can make their mind to file in respective zones or the regional offices. For example, suppose I want to file my patent application in Germany. So what I will be doing, because I'm from India, so first of all I would be filing an application in India side by side. I will be following the PCT route. So I will file a PCT application. PCT will cover the entire major countries, 157 contracting states, and this way I'll book my priority date. And then later on, if I'm seeking it in Germany, I would be applying again in that particular country, Germany. So that's what is known as Patent Cooperation Treaty, and so treaty would be defining certain set of rules which would be followed by every regional or the national country which is a part of PCT. Now let's understand what is this International Bureau of WIPO. What is the role of International Bureau of WIPO? It is responsible for the coordination and management of the PCT system internationally. This involves the communication, review, processing, and publication of PCT applications and associated documents received by WIPO. Now let's have a look on the process of PCT application filing. So what happens in international phase and then what happens in national phase. So we'll understand all these things deeply, but just to give an overview, there are certain steps which on international level the application has to face. So first of all, I want to enter to international phase. So for that, filing of a PCT application is required, and then international search would be held, then international publication would be done, supplementary international search results would be provided, and then international preliminary examination report would be given, right? So based upon that, further an applicant can actually enter into the national phase. So wherein again the processing of the PCT application happens before national regional patent office. So again the example which I gave, like first I would be going through the PCT route, and then based upon all the results, all the international preliminary examination, the search reports and everything, I can actually get to know like the chances or I'll say yes, the chances of my application to be granted. For that, I will again, entering the national phase of Germany. So I'll see as per their patent laws and regulations whether my application is there in the format, or else they need some other information. Accordingly, I'll come in, and then we can enter to the national phase. Now let's understand about the filing of a local patent application. So how generally a first patent application is filed. So basically, the process starts as soon as you go and just file a local application with your regional office. So typically, a national patent application, the home country of the applicant, is called the first patent application, right? And from here you can actually decide, so you get the time. From here you get 12 months time to actually file a PCT application. So we'll learn in the next slide. So what comprises of this local application? So local application, it contains the following elements: a request or a petition, a description, also referred to as specification, one or more claims, an abstract, one or more drawings, wherever necessary. So all these things you would be including in your first application, and then you would be filing it for the PCT phase. So you get 12 months time to enter to the PCT phase. So you are filing PCT application. So typically file in same national patent office. For example, if I'm actually uh, filing a patent and I'm seeking to follow a PCT route, so first I would be actually addressing my nearby regional patent office, maybe Mumbai or Delhi or anywhere else. So wherever is near to me, according to the zone, I can actually file my first application. And then it would be required from my side to actually submit one set of fees, and then again the application in one particular language, one set of formality requirements, and then legal effect in all the PCT states. So basically what is happening, through single set of fees in one language, in one set of formality requirements, you are actually booking your patent application in all 157 contracting states or countries. So that's the beauty of this PCT route or PCT application. So now let's talk about the procedure of filing of a PCT application. As we discussed already, that the PCT application can be filed within 12 months from the date of filing of the first or the local application with the receiving office of your national regional office. One can also file the PCT application with the receiving office of WIPO if abide by NSR of the national laws. Now, once you have submitted the PCT application, you have filed the PCT application within 12 months time frame from your first or local application, you can actually await, or you can actually demand international search report or a written opinion. So what it is, how international search report comes out, and what kind of written opinions the authorities give. So let's talk about this. The PCT contracting states have designated specific international searching authorities, which we call ISAs, to conduct international searches and issue written opinions for their applicants. These ISAs are known as the competent international searching authorities in PCT terminology. Approximately 16 months after filing your local application, you will receive an international search report and a written opinion from a national or regional patent office acting as an ISA under the PCT selected by the applicant if multiple competent authorities exist. The ISR will include references to patent documents and other technological sources relevant to assessing the potential patentability of your invention. So ISR here in this phase only check whether this particular invention is patentable or not. The written opinion supplements the ISR by offering a preliminary, non-binding evaluation of the patentability of your invention based on the references in the ISR. Now let's talk about the International Preliminary Report on Patentability. If you choose not to request an international preliminary examination after receiving the ISA's written opinion, WIPO will attach a cover sheet to convert the written opinion into an international preliminary report on patentability. This report will then be available for public review 30 months after the priority date of your PCT application, the date you filed your initial local patent application. So this is the entire procedure. You first go ahead and file local application, then within 12 months of time frame you go ahead and file PCT application. Within next up to 16 months you may get international search report and written opinion, and accordingly you can actually get it in the form of a report. The written opinions can be actually received in the form of report, and then this report will then be available for public review uh, 30 months after the priority date of your first order PCT application. Now let's talk about the supplementary international search report, which is actually optional. So before 22 months from the priority date, you can optionally request a supplementary international search for your PCT application. This supplementary search, conducted by a different international searching authority, can provide a more comprehensive review of prior art, particularly in specific languages. However, not all authorities offer this service, and there is typically a fee involved. The supplementary international search report should be available by 28 months from the priority date. Let's understand about the filing of a demand for international preliminary examination. This should be noted that this particular phase or this particular process is optional. You may demand or you may not demand. So according to the ISR written opinion, an applicant can request a second patentability assessment on their amended application by filing a demand for international preliminary examination with the national or regional patent office within 22 months of the priority date. So this is a kind of request wherein you are requesting for an additional patentability analysis on basis of amended application. Now let's understand when would you be receiving the international preliminary report on patentability. So approximately 28 months following the priority date, the International Preliminary Examining Authority EPA will issue an international preliminary report on patentability. This report will include the EPA's assessment for national or regional offices to consider when evaluating the patentability of your invention as presented in your typically amended application. So it is important to note that this report serves as a non-binding procedure or non-binding patentability report or opinion and is exclusively available to applicants who have requested or demanded for international preliminary examination. Now let's understand what happens when the application enters the national phase or the applicant is applying for a designated country. The international patent procedure concludes, marking the start of the national phase patent procedure. The international preliminary report provides insights into your patent's likelihood of success in the target country. This report then guides the regional or national patent office in their decision to grant the patent. The patent application process adheres to the specific patent laws and regulations of the country where it is filed. Thank you everyone for listening to this session of PCT. Hope you learn and you enjoyed. Thank you the academicians who and experts who actually developed this module on WIPO distance learning courses. Thanks a lot.